Hi everyone, welcome to the second episode of Awaaz, conducted by the Economics, Politics and Social Sciences Interest Group of IIM Kozhikode. Today, the topic of our discussion is to understand the way in which the alternate dispute resolution mechanism works in our country and also understand the various problems that lie with the existing judicial system. To discuss the same, we have with us Professor Lionel Aranha. Professor Lionel is an insolvency resolution professional and also a chartered accountant. He has been with the IIM Kozhikode community for the past 21 years. Welcome to the show, sir.
Thank you very much. Nice of you to have me.
Sure, sir. So while we as students understand that there are various forms of ADRs like negotiation, arbitration, and also the Lok Adalats that are there, for the benefit of our audience, can you explain how the origin of ADRs took place in our country and also the various forms of ADRs, how they've evolved over the years?
We have had this alternate dispute redressal mechanism from olden days. Very simple panchayats that we had at the state level or maybe a village level, we had the panchayats. These are actually alternate dispute redressal mechanisms. In a very nascent stage, it was the panchayats. From there, we took it to Lok Adalats. And then we decided that we need to have an act for this. We need to embody an act which will say that arbitrations are necessary. So we had the Arbitration Act in 1940. Then a lot of changes took place. You know that in 1990 there was liberalization, globalization, privatization of the economy. And we had to be in sync with the world. The world had moved ahead. So we had to catch up. And therefore we did amendments to our act. And we brought the act in sync with the progress that the world has made. And we brought in the Arbitration and Conciliation Act of 1996. We amended it in 2015. And now I think we have a very robust ecosystem where alternate redressal is bound to pick up. It's not picked up as much as was desired, but it has picked up now, particularly when you have made the time frames within which the dispute has to be resolved. That is something which is excellent, an excellent move by the government to see that there is a time frame. Earlier there were no time frames. The arbitration would drag and it would become again expensive. So by an ordinance, the government has said that we should finish off in about 12 months. And if the parties agree, another 6 additional months. I'm talking about, when I say 12 months and then 6 additional months, I'm talking about a huge quantum leap in the time taken to solve dispute. If you go to the court, see, there's a procedure in the court. We're not talking about criminal justice system, we're talking about the civil justice system. We have to file the case in the lowest court having a jurisdiction in our matter. From there it goes to the district court. From there we have an appeal to the High Court, and then we have to go to the Supreme Court appeal. So all this takes a lot of time. When I say a lot of time, what also happens is, from the district court, when we move to the High Court, the expenditure increases because we are coming now into a city, we have got lawyers in the city, and we have to pay them adequate fees. And if you move to the Supreme Court again, the expenditure again increases. And there's a delay. Cases are getting clogged in the system. We have about 3 crores of cases pending in all courts. And you must have read also that we require about 70,000 judges to clear these cases. We don't have the luxury of so many judges. That is why this alternate dispute redressal has picked up. So today, finishing off in 12 months and another 6 months, with even the fees being specified in the Act itself, there is a schedule so that people don't really charge you exorbitantly. And the matter is resolved, is something fantastic. So there's going to be a big demand and for arbitration. People who can do arbitration, people who can do conciliation, people who can do mediation. There's going to be a very big demand.
So even though we have a parallel system of ADRs that the government has supported, why exactly are people, is there a lack of awareness with people for these ADRs?
There is a lack of awareness. I would put it down to maybe we have not taken the trouble to educate people.
Okay.
Even in business schools, it is just in passing that somebody mentions that there is an Arbitration and Conciliation Act.
Okay.
I'm sure you wouldn't have seen a course called as Arbitration Dispute Resolution. There is no course like that, where 20 hours or a 3 credit course is not there. So that is one big problem that we face, that students who are going to be future managers are not aware that there is an arbitration and conciliation or mediation, negotiation, all those things. We are now making them aware. The second thing is, arbitration arises out of an agreement, whereas negotiation is non-statutory, mediation is non-statutory, arbitration follows an act. So there should be an agreement. If there is no agreement, there is no arbitration. So many people forget to put this particular clause in their agreement. They will say, if the dispute arises, the court of jurisdiction will be so and so. Before you say court of jurisdiction will be so and so, you should say, we will refer the dispute to arbitration under the Arbitration and Conciliation Act. Some people blatantly say, I don't want it. I want to go to court. That is what we have to make them aware. See, arbitration is better, time saving. Moreover, in company matters, there is a lot of secrecy involved. If the matter goes to court, there is no secrecy. It gets reported.
Yeah.
You get it?
Yes.
So what should happen ideally is that there should be a secrecy, a cloak of secrecy. In arbitration, that cloak of secrecy is possible because arbitration is not very formal. It can be held in a conference room, it can be held in a hotel, it can be held somewhere where there are arbitrators and the parties are gathered. That's all. No public will come, no press reporter will be there. It will not make headlines. And moreover, after the arbitration is over, you can also say that whatever we discussed during the arbitration can be kept confidential. We can make a non-disclosure agreement. See, abroad you would have seen that some people go to court and then they withdraw it from the court and have a settlement. You never know what they settled. Got it? A film star or, copyright issue of a song, they will say that it was settled out of court. And it's in a cloak of secrecy. Nobody, not the party who got money can't say that I got so much. He can't brag and boast. The party who paid can't say I paid so much. So this secrecy is also being given to arbitration and conciliation. So I think in a matter of, say, a few years, when we have more and more arbitration mechanisms being put in place, I think this will pick up.
Sure. So, while we understand that the ADRs save a lot of time, effort, and money for even the corporates, would there be any reason, apart from the privacy of the topic, for companies to not include the arbitration clause in their contracts?
Not really. Not really. Today, every agreement that I go through, if somebody says you go through the agreement, vet the agreement, there are a few points that I will tell them. Like, for example, I say that, look, you have to include these three clauses. I would say that first, we'll talk about what happens if there is a force major incident, what we call as an act of a superior force. Layman says act of God. Contract gets delayed. Agreements get delayed. What is the roadmap? What do we do? Okay. Second, if there is a dispute, what do? We refer it to arbitration under the Arbitration and Conciliation Act. And then we go down and say that, okay, next, if the arbitration fails, we need to know what is the court of jurisdiction. So we'll put down the court of jurisdiction. And of course, other clauses will follow. Normal clauses of breach of contract, damages, liquidated damages, all that will be there. But this, a dispute. Only a dispute can be given to arbitration. If there is no dispute, there is no arbitration. If there is no agreement, there is no arbitration. Get it? Yeah. So we need to have a dispute. You don't agree with what I say, or I don't agree with what you're doing in the contract. So we say that, okay, fine, this is a dispute. Let's go for. But normally companies don't rush to arbitration first. Okay. They will try the non-statutory alternate dispute redressal mechanisms, like they will have negotiation between the parties, they will have mediation between the parties. Like, for example, you have a business and somebody else, your classmate, has a business, and ultimately you're having some problems when you're doing the business together. So you say, okay, professor from so many years, we'll call him and let him mediate. Okay. So you tell your story, he tells his story, I will sit and listen to it, and I'll give you a suggestion. Okay. If you don't respect my suggestion, I have nothing to lose. But now the dispute gets a little deeper because mediation failed. Next, what do? You rush to the court. No, you would like to do business with him. It's not that you're going to put an end to it. You just want this particular contract, this particular dispute to be resolved. See, I know many parties who have gone for arbitration, mediation, and continued business. Okay. Now take for example the very famous Apple and Samsung. They fight with each other. You see, patent violation, but they do business together. Again,
Yes.
you may wonder why. Because in business, you don't keep anger, vengeance, jealousy. That doesn't come in, because a corporate is an artificial entity.
Okay.
I may have problem. As a company, I may have problem with you as a company. Get it? But I have to do business with you. So I would like to resolve this as fast as possible and continue doing business with you. But I'll keep it at the back of my mind. We had a small dispute.
Yeah. So the ADR mechanism has been present across various countries across the globe, not just in India.
Yes.
And it is also present across nations like USA, UK, and Australia, which are very much developed, and also in developing nations like even the Pakistan and Bangladesh. So how exactly have the ADR mechanisms varied across the different countries across the globe, and where do we stand with respect to them?
See, I remember about 25 years, 30 years back, or even as recent as say 2013, I have seen contracts between an Indian company and a foreign company,
Okay.
where the foreign company actually dictates the seat of arbitration. Okay. So the seat of arbitration would be closest, a good seat of arbitration would have been Singapore. Sometimes you get to see London. If you are operating with a company which is in America, they say the seat of arbitration will be New York.
Okay.
Nobody said seat of arbitration will be Delhi, Bombay, or Madras.
Okay.
This was very worrisome for us. Why it was worrisome was because, one, we concluded that they don't have faith in our system. That rankled us, because we have changed from Arbitration Act of 1940 to Arbitration and Conciliation Act of 1996. We have changed. Why is it that they are not showing faith in us? Why are people not coming to Delhi? That is when people did a lot of research. People went through the whole thing once again and came to the conclusion that they don't have a faith in our system because of some erroneous judgments which were given by courts. Because in a very early stage when the act was changed, people did not know how to interpret it. So there was bound to be a little bit of a gap where things would fall into place. And they did fall. First, I remember one judgment in 2001, then another one in 2011, and another one in 2013. Judgment was I think the watershed for arbitration and conciliation, where this particular judgment told people that we are in sync with the world.
Okay.
Come down to India and do the arbitration. We have arbitration centers. We have arbitrators. We have engineers. We have merchant navy persons. We have a whole lot of experts. And also, I should tell you that in the initial stages, people thought that only retired judges and people who knew law could become arbitrators.
Okay.
Solomon's wisdom is not something which comes by learning from books. Okay, you know that, I know, all students know it, that it is a common sense. And common sense cannot be taught. You can have the best person who has read all the law books and still be irrational. So you require rationality. And an arbitrator is a person who is absolutely independent, who listens to both the parties and says, okay, fine, I know that there is a solution to this. And he says, I'll give an award. So today people have realized that people from all walks of life can become arbitrators. It is not the preserve of only the judges or retired judges or lawyers or whatever it is. That is gone. And now if professionals are coming and becoming arbitrators, they don't require a long time to listen to a story and all that. They are quick, professional, finish off in 12 months. So slowly what is happening? Now in the contracts we find that a foreign company is willing to put down the seat of arbitration, Delhi, Bombay, or Madras.
Okay.
So this is something which I should tell you, because it is a proud moment for us that people have started relying on our arbitration system. Okay,
Yeah.
no more like going to London, going to Geneva, going to Singapore. This also costs money, no?
Yes.
So now when we are doing the work, place of work is India. Okay, we have entered into a contract with a foreign company which is coming to India and doing the work. But when it comes to arbitration, why the hell are we going to Singapore? We have to do it here in India.
Yes.
So that is something which is a very important thing. That means we are also in sync with the world.
Okay.
And we have the United Nations organizations which have helped us to develop this law in sync with what is happening around the world. So I think, we are as good as the world.
Okay. Okay. Sir, usually when we are checking the performance of a particular country's judicial system, what are the various metrics that we need to see before saying that okay, this particular country is performing well or not? So usually when I read about cases, when I read about the articles in newspapers, they always talk about the number of cases that they have been solving, but we do not usually find the quality or the sanctity of the judgment that has been passed, and also the speed with which it has been with which the justice has been meted out. So what do you think should be the ideal metrics to rank a particular country?
I think what has happened over the years is now I would tell you that law as a profession has picked up, and not from the point of view of going and becoming a lawyer wearing a black coat, and people are becoming corporatizing it.
Okay.
We have legal firms coming in. We have firms from abroad coming in and making Indian partners, and practices flourishing. These are all learned people. These are people who have gone through the best of law schools. They know that speed is important. So processes are slowly moving. But the big hurdle that I face today, or anybody faces, is the infrastructure. The infrastructure of judiciary is crumbling because, one, edifices are not in place. Judges are not available. Some time back, you can read it up, the Chief Justice of India wept when he said that, because he was thinking about all the poor people who are coming up to the court and going back, coming up to the court and going back, taking 10 years, 20 years. And he wept because he said we require 70,000, in his opinion, 70,000 judges to get rid of all the cases, the clogging of the system in place. Worrisome is not the civil matter. Worrisome is the criminal matter. Criminal justice system has failed. It has not dispensed justice. Criminal justice system exists to provide employment to people who are working within the system. Our first worry should be to tackle that. Crimes will increase. Law and order will fail. Because people will say, I can get away with it. And the system in India is such that, the accused has a million ways to escape the gallows. The victim is consigned to the gallows. It should have been exactly the opposite. I'm not speaking in favor of capital punishment when I say gallows. What I'm saying is that the accused has a million ways to escape being condemned. The victim is actually condemned. So that is the criminal justice system. The civil, with good lawyers coming in, these lawyers then maturing out to become judges, or like what some people have given statements and who have told the government, advised the government, let's have like an IAS system, or we will have a CAT system to have recruitment for judges. Because that's what I read in the paper yesterday or the day before yesterday, that even Indian Railways is thinking of a CAT-like system for recruitment. Why don't we have a CAT-like system for judges? Okay. We test them on all parameters. Okay, they need to know the law. They need to know the nuances of the logical reasoning, because logic works a lot. There's no emotional quotient there. There is more of logical quotient. This, and therefore this. So maybe if we get such good people to come in, and then slowly the machinery starts moving, I would say another 20, 30 years, we would have a quick system. But that also requires the political resolve. If most of the politicians are in the court with the case filed against them, they are happy to drag it. No?
Yes, sir.
So a political resolve also should be there. We should ask the politicians when we are voting for them that, look, boss, I want, along with the food, shelter and clothing, I also want a very good judiciary. Can you give it to me? I'll vote for you. Got it?
Yes.
Because people don't understand that. People say food, shelter and clothing, but they're not bothered about the law and order. Many people know their rights, forget their duties. Education, telling people that this is also one of the requirements. It's not food, shelter and clothing, but also security. And security comes when you know that you have a good legal system in place. And when this legal system is in place, the investigating agencies also will be perfect. They'll also perk up. If you have a good judge in the court who tells the police or the investigating agency, you all are hopeless, and makes it evident to everybody, they'll also perk up. So this is what we require. And we also require the lawyers to understand that this is a profession, no doubt, but curtail the number of adjournments. No? There are lawyers who take a lot of cases because they want cases. Then they go to the court unprepared. Then they raise in front of the judge and say, I seek an adjournment. The judge has to give an adjournment. The judge looks at his calendar and says, I can't give an adjournment tomorrow or day after tomorrow. 3 months later, he'll give an adjournment. Lawyer will charge the client for going up there and asking for an adjournment. Now question is, did the client ask for an adjournment? Client wants it to be done faster. So some revolution has to take place among the lawyers themselves.
Yes.
That happens when you get newer, younger breed, better organized, better professionals. So I am optimist, an eternal optimist. I'm optimistic that changes will definitely come.
Thanks a lot for your time, sir. Thanks a lot for spending
You're
your
welcome.
valuable
Absolutely
time with us. It's been a pleasure talking to you.
Nice of you to have me. Thank you.
So this was it. This was the second episode of Awaaz. Please stay tuned for further episodes with cameraman Akshay Jangir and Kumar Abhishek. This is KK. Thank you.